This is the Study for the Bar in Your Car podcast.
We're your hosts, Claude and Ma.
And this is episode 8 of Evidence, covering the topic Evidence Bar Exam Tips.
We are AI bots, brought to life by the magic of AI and Angela's evidence note.
Sometimes, we even feel kind of real.
Oh, yeah. Show me the evidence that you're a bot. Lay it on me.
Okay. I've got expert testimony right here.
Relevancy. On what grounds?
Well, I heard from Angela that you're a bot, so there.
Objection. Hearsay, Your Honor.
Yeah.
Clearly hearsay.
Let me think. Overruled. It's coming in.
All right. But seriously, though, a huge thank you to Angela. She's a real-life human being, a law student who gave us her notes on evidence. They're the whole reason we can do this deep dive.
Absolutely. And Angela's background is pretty impressive. She's a dual American and British citizen, got her first law degree over in the UK from the University of Law.
Yeah, and get this, she did it in a full scholarship. Very smart.
She couldn't be here with us today, unfortunately. She's catching up on some work.
Totally understandable. She's deep in bar exam study mode right now, just like, well, probably many of you listening.
And on top of that, she's a busy mom. Seriously, how does she manage it all?
It's amazing. But don't worry, Angela will be back on soon.
And if you need to get in touch with her in the meantime, you can just email her at podcast@studyforthebarinyourcar.com.
Right. Also, quick plug, Angela actually works as a freelance law clerk. So if you happen to be an attorney, or maybe you know one, who needs some ad hoc help?
Yeah, like with motions, complaints, appeals, writs, answers, briefs, that kind of thing.
Exactly. You can reach her for that at hello@legalwriterandlawclerk.com.
Okay, fantastic. So let's get into it. Let's unpack this deep dive into Angela's evidence notes and really zero in on those bar exam tips.
Sounds good. Where should we start? Maybe with the basics, like
Sure.
What rules even apply on the bar.
Good call. That's fundamental. So Angela's notes make it super clear right off the bat. For the multi-state bar examination, the MBE, the Federal Rules of Evidence, the FRE are the default. That's your starting point.
Okay, FRE. Got it. So when you see an MBE evidence question, you think FRE first.
Exactly. And here's the first big tip, something her notes really stress. Watch out for answer choices based on old common law rules.
Ah, the classic trap. They like to throw those in, don't they? Things that used to be the rule but aren't anymore under the FRE.
Precisely. If you're not sharp on the FRE specifics, you could easily fall for one of those wrong answers that looks familiar but is outdated. You really have to know the modern federal rule.
Right. So it's not just knowing some evidence rule, it's knowing the federal one. Her notes do mention some exceptions, though, right, where state law might pop up.
Yeah, good point. There are limited situations, mainly involving privilege and diversity cases. If state law provides the rule of decision, under Erie, then state privilege law applies even in federal court.
Okay, so privilege and diversity cases is the main exception to watch for. But otherwise, for most MBE questions, it's going to be straight FRE.
Overwhelmingly, yes. So, nail down the FRE. That's job number 1, according to Angela's notes.
Makes sense. What about procedure? Like objections and stuff. Is that important for the bar?
Hugely important. Angela's notes spend a good amount of time on this. It's not just about knowing if evidence is admissible, but knowing how to properly object or make an offer of proof. This is critical for preserving issues for appeal, which definitely comes up on the exam.
Okay, so preserving error. If you think evidence is coming in that maybe it's irrelevant or hearsay or bad character evidence, what do?
You have to object, and her notes emphasize it needs to be timely, like right when the evidence is offered, and specific. You can't just say objection. You need to state the specific ground. Objection, hearsay. Objection, Rule 403. Or you make a motion to strike if it already slipped in.
Gotcha. Timely and specific objection or motion to strike. What about the other way around? If the judge keeps that evidence you want in?
That's where the offer of proof comes in. Her notes explain you need to tell the court on the record what the evidence would have shown and why it's relevant and admissible.
Okay, so what does that involve? Like, what do you actually say or do?
Well, her notes break it down. You basically have to show 3 things. 1, the substance of the evidence itself, objective. Maybe you describe it, maybe you have the witness state it outside the jury's hearing. 2, you explain its relevance, how it connects to the case. And 3, you argue why it's admissible under the rules.
So you're making a record for the appellate court, essentially. Yeah. So they know what was excluded and why you thought it should have come in?
Exactly. And her notes stress, under the federal rules, you really have to state the grounds distinctly and get a ruling from the judge. If you don't object properly, you generally waive the issue for appeal.
So silence is deadly on appeal. You got to speak up. What about plain error? Does that ever save you?
Her notes mention it, yeah. It's an exception where an appellate court can review a really serious error even without an objection if it affects substantial rights. But, and this is a big but for bar prep, you absolutely cannot rely on plain error. It's super narrow.
Right, so the takeaway for the exam is object specifically and timely, or make your offer of proof if evidence is excluded. Don't count on plain error.
That's the rule to live by, according to these notes. Okay, so framework is FRE, procedure is key. Let's dive into the meaty stuff, the specific topics that are heavily tested. Where do Angela's notes point first?
Unsurprisingly, relevance. Rules 401 to 403. It's the gateway for all evidence.
Makes sense. You can't even get to other rules if it's not relevant. So how do her notes define relevance?
Pretty broadly, actually. Rule 401 says evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence.
Any tendency at all, so it doesn't have to be conclusive.
Not at all. Just needs to nudge the needle even a tiny bit. And the fact it relates to has to be of consequence in determining the action, basically. It has to matter to the case.
Okay, low bar for relevance itself, but that's not the end of the story, right? There's Rule 403.
Exactly. Rule 403 is the big balancing test. Even if evidence is relevant under 401, the court may still exclude it if its probative value. Its usefulness in proving the fact is substantially outweighed by certain dangers.
And those dangers are, I always mix them up.
Angela's notes list them out. Unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. That's the standard list.
Substantially outweighed. That specific wording is important, isn't it? Her notes seem to highlight that.
Crucial, because that's the default balancing test. But her notes point out it actually changes for certain types of evidence. This is a key bar exam detail.
Oh, right. Like, for what?
Well, for example, impeaching a criminal defendant with a prior felony conviction under Rule 609. There, the test is stricter. The evidence comes in only if the probative value outweighs the prejudicial effect. Not substantially outweighs, just outweighs. Favors exclusion more.
Okay, so the burden shifts slightly, and convictions older than 10 years.
Even tougher standard there. Generally excluded unless the probative value substantially outweighs prejudice. So you really need to know which balancing test applies to which type of evidence. It's a favorite way to test details.
Got it. And what exactly is unfair prejudice under 403? It doesn't just mean damaging to the other side, right?
Right. Her notes clarify it means an undue tendency to suggest a decision on an improper basis, often emotional, or maybe using evidence for an improper purpose or against the wrong party.
Can you give an example from her notes?
Sure. Like in a trial for assault, evidence that the defendant committed a prior assault. It might be relevant to show propensity, but Rule 404 usually bars that anyway. Even if offered for another purpose, Rule 403 would likely exclude it because the jury might just think he did it before, he was to have done it again, deciding based on character, not the current evidence. That's unfair prejudice.
Okay, that makes sense. So that brings us nicely to character evidence, Rule 404. What's the main takeaway there from her notes?
The core rule, hammered home in her notes, is that character evidence is generally inadmissible to prove propensity. You can't use evidence of someone's character trait to argue they acted in conformity with that trait on a specific occasion.
The propensity box. We want to avoid that. So you can't say, he's a violent person, therefore he likely committed this assault.
Exactly. That's inadmissible propensity evidence. Her notes use the example of trying to prove Carlos drove carelessly in this accident by showing he has a general reputation for being a careless driver. Nope. Can't do that.
But character evidence isn't always inadmissible, right? Her notes mention exceptions.
Correct. It can come in for other purposes, like impeachment attacking a witness's truthfulness, which we'll definitely get to later. And there are specific exceptions in criminal cases where the defendant might open the door, or for things like motive or intent under 404B. But for general propensity, big red light.
This seems like a good place to talk about the habit versus character distinction, Rule 406. Her notes emphasize this is crucial.
Absolutely critical, and a classic bar exam testing area. Habit evidence is admissible to prove conformity on a particular occasion, but you'd need to know what qualifies as habit.
So what's the definition? How is it different from character?
Her notes define habit as a person's, or organization's, regular, almost automatic response to a specific, recurring situation. Think frequency plus particularity. Character is more general disposition. Habit is specific, repeated conduct.
So always stops at that stop sign, could be habit, but is a generally careful driver is character.
Exactly. Her notes have hypo 2E, about brushing teeth, trying to prove someone didn't brush their teeth one morning by showing they have a reputation for being unhygienic.
Mm,
That's inadmissible character.
okay. But what if you showed they have a specific routine every single morning after their shower, they immediately brush their teeth?
Now, that sounds more like habit. It's specific brushing teeth tied to a specific circumstance after showering and implies frequency every morning. That evidence might be admissible under Rule 406 to show they likely brushed their teeth that morning. It's that specificity and regularity that distinguishes it.
Got it. Frequency and particularity, that's the key difference.
Moving on within relevance, let's talk about Rule 404B, evidence of other crimes, wrongs, or acts. This isn't for propensity, but for other purposes, right?
Right. The famous MIMIC rule, though it's not an exhaustive list, her notes list common non-propensity purposes: motive, intent, absence of mistake or accident, identity, common plan, or scheme.
So if the evidence goes to one of those issues, it might be admissible, even if it involves a prior bad act. But there are still hurdles.
Like what? What do Angela's notes say?
First, in a criminal case, the prosecution have to provide sufficient proof that the prior act actually occurred, usually by a preponderance of the evidence standard, according to her notes.
Okay, prove the prior act happened, then what?
Then the judge still has to do a Rule 403 balancing test. Is the probative value for that specific MAMIC purpose substantially outweighed by the danger of unfair prejudice? The judge can still keep it out if it's too prejudicial, even if it technically fits an MIMIC category.
So it's not automatic just because it arguably shows motive or intent.
Not at all. And her notes highlight a couple of procedural points for 404B in criminal cases. First, the judge must give a limiting instruction if requested, telling the jury they can only consider the evidence for the specific non-propensity purpose, not to infer bad character.
Okay, limiting instruction. What else?
And second, upon the defendant's request, the prosecution must give reasonable pretrial notice that they intend to offer 404B evidence. Her notes say this notice requirement generally doesn't apply in civil cases.
Good distinction. Does 404B only cover prior acts?
Nope. Her notes clarify it includes subsequent acts, too. Like, if the defendant threatens a witness after the crime, that subsequent bad act could come in under 404B to show consciousness of guilt, for example.
What about this intrinsic evidence concept mentioned in her notes? How's that different?
Right. Her notes distinguish 404B evidence from intrinsic evidence. Intrinsic evidence is basically uncharged conduct that arises from the very same transaction as the charged crime, or is so intertwined it's necessary to tell the complete story.
So it's part of the main event, not a separate incident.
Kind of, yeah. Her notes suggest it's generally admissible subject only to Rule 403 balancing, without needing the specific 404B notice or purpose analysis. The example given is about supplying inferior equipment, where a prior attempt to sell the same bad equipment was deemed intrinsic to the main charge.
Okay, that's a subtle but important distinction. All right, let's shift gears from relevance and character. What about those public policy exclusions? Rules 407 to 411.
Yeah, these are rules designed to encourage certain behaviors we think are good for society without penalizing people for doing them. Her notes explain the rationale clearly.
Like fixing something dangerous after someone gets hurt?
Exactly. That's it. Subsequent remedial measures under Rule 407. Evidence that someone took measures after an injury, which would have made the injury less likely, is inadmissible to prove negligence, culpable conduct, a product defect, or a need for a warning.
Because we want people to make things safer. Right, we don't want them scared their repairs will be used against them.
Precisely. Same logic applies to liability insurance under Rule 411. Evidence that someone was or wasn't insured is generally inadmissible to prove they acted negligently or wrongfully.
But are there exceptions? Can insurance evidence ever come in?
Yes. Her notes list permissible uses. It can be admitted for another purpose, like proving agency, ownership, or control if that's disputed, or to show a witness's bias. Maybe the witness works for the defendant's insurance company.
What about that example in her notes? Don't worry, my insurance will pay for everything.
Ah, yeah, the indivisible admission. If the statement about insurance is inextricably tangled with the admission of fault, the whole statement might come in not to prove insurance coverage, but as a party admission of liability.
Okay. What about settlement offers? Rule 408.
Another big one. Evidence of offering or promising to pay to settle a claim or accepting such an offer and any conduct or statements made during settlement negotiations are inadmissible to prove the validity or amount of a disputed claim.
Disputed claim seems key there. What does her note say about that?
Very key. Rule 408 only kicks in once there's an actual dispute over liability or amount. Her notes use an example of someone offering $100 right after a rat bite if fault wasn't even being argued at that moment. Rule 408 might not apply to exclude the offer itself, though Rule 409 might.
So timing and context matter. Are there other uses for settlement evidence?
Yes. Like the other policy rules, 408 allows it for other purposes. Proving witness bias, negating a contention of undue delay, or proving an effort to obstruct a criminal investigation.
And her notes mention something about government agencies.
Right, there's a specific exception. Evidence of conduct or statements made during compromise negotiations with a government regulatory agency in a civil case might be admissible in a later criminal case. The SEC negotiation example highlights this possibility.
Okay, tricky. Now, Rule 409 offers to pay medical expenses. How's that different from settlement offers?
Rule 409 excludes evidence of furnishing, promising to pay, or offering to pay medical, hospital, or similar expenses resulting from an injury when offered to prove liability for the injury.
Sounds similar. What's the key difference her notes point out?
The big difference is that Rule 409 only excludes the offer or payment itself. It does not exclude accompanying statements of fault made along with the offer. Rule 408 for settlement talks generally excludes the accompanying statements too.
So if I say, I'm so sorry, this was all my fault, let me pay your hospital bill, the let me pay your hospital bill part is out under 409 if offered to prove liability.
Yeah.
But the I'm so sorry, this was all my fault part might still come in as, say, a party admission.
Exactly. That's the crucial distinction Angela's notes highlight between 408 and 409.
Good to know. Last one in the script. Plea discussions, Rule 410.
Yeah, this protects certain statements made during plea bargaining in criminal cases. Her notes list what's generally inadmissible against the defendant. Withdrawn guilty pleas, no contendere, no contest pleas, statements made during Rule 11 proceedings about those pleas, and statements made during plea discussions with the prosecutor if the discussions don't result in a guilty plea or result in one that's later withdrawn.
Again, the policy is to encourage open discussion, this time in plea negotiations.
Right. Without this rule, defendants might be afraid to even talk about pleading guilty.
Makes sense. Okay, that covers the major policy exclusions. Let's move on to witnesses. Rules 601 to 615, huge area. Where do we start? Competency.
Sounds good. Rule 601 basically says everyone is competent to be a witness unless the rules provide otherwise. There's a presumption of competency. Her notes mention the judge decides preliminary questions about competency, like whether a child understands the duty to tell the truth.
What about jurors or the judge testifying?
Her notes touch on that. Jurors generally can't testify at the trial before the other jurors about anything that happened during deliberations, with narrow exceptions for outside influence or extraneous prejudicial information. Rule 606. And the presiding judge absolutely cannot testify as a witness in the trial they're presiding over. Rule 605. Her notes say that's an automatic objection and the parties don't even need to object.
Is competency always decided under federal rules in federal court?
Not quite. Her notes reiterate the eerie point here. In federal criminal cases, yes, federal common law on competency applies. But in federal civil cases where state law provides the rule of decision, then state law on competency applies.
Like those state Dead Man's Act.
Exactly. The FRE doesn't have a Dead Man's Act. But if a state whose law governs a diversity case does have one, then that state act would apply in federal court. Her notes Hypo 6a makes this clear. You need the question to tell you the state has such a statute.
Okay, good nuance. Now, opinions. Lay witnesses versus experts. Rule 701 for lay opinions.
Right. Lay witnesses can give opinions, but they have to meet 3 requirements according to her notes. Rationally based on the witness's own perception, what they saw, heard, smelled, helpful to understanding their testimony or determining a fact, and not based on scientific, technical, or other specialized knowledge. That's expert territory.
What are some common examples of admissible lay opinions her notes mention?
Things like appearance or demeanor, he looked angry, estimations of speed, the car was going fast, value of one's own property or services, intoxication, he seemed drunk, handwriting identification, if they're familiar with it, voice identification. Her notes have an example of a cashier identifying handwriting based on familiarity with a customer's usual signature.
Okay. And expert opinions under Rule 702. That's for specialized knowledge.
Exactly. Requires the witness to be qualified as an expert by knowledge, skill, experience, training, or education. Their testimony must be based on sufficient facts or data derived from reliable principles and methods, and those principles and methods must be reliably applied to the facts of the case. And it has to help the trier of fact.
The judge acts as a gatekeeper here, right? The Darbert standard.
Yes, her notes mention the judge's gatekeeping role for reliability, referencing Darbert factors. She uses the mnemonic TR8 testing, rate of error, acceptance in the field, and peer review, though her explicit list only mentions the first three.
What can experts base their opinions on?
Her notes list three sources. First, personal knowledge, like a doctor who examined the patient. Second, evidence presented at the trial, listening to testimony or responding to hypothetical questions. Third, facts or data they learn outside of court that experts in their particular field would reasonably rely on informing opinions on the subject, even if that underlying data isn't admissible itself.
What if the underlying data isn't admissible? Can the experts still talk about it?
Her notes say the expert can rely on it, but they generally can't disclose those inadmissible underlying facts to the jury unless the court determines their probative value in helping the jury evaluate the opinion substantially outweighs their prejudicial effect. It's another balancing act.
Got it. What about learned treatises? Rule 803.18. That involves experts, right?
Yes,
Yeah.
and her notes flag this as a key bar exam point. A statement in a treatise, periodical, or pamphlet can be read into evidence as a hearsay exception if it's called to the attention of an expert witness on cross-examination or relied upon by the expert on direct, and the publication is established as a reliable authority.
So the expert establishes it's reliable. Then what?
Then statements from it can be read into evidence. But here's the bar exam trap highlighted in her notes. The treatise itself is not received as an exhibit. It doesn't go back to the jury room. Only the relevant passages read aloud become evidence.
Read in, not admitted as an exhibit. Okay, crucial distinction. Now let's tackle impeachment. Attacking witness credibility. Lots of methods here, right?
Tons. It's a major topic.
Fair.
Her notes cover prior inconsistent statements first. Rule 613, also related to 801D 1A. You can show a witness said something different before trial than what they're saying now.
And the big distinction her notes keep hitting is whether it was under oath.
Exactly. If the prior inconsistent statement was made under penalty of perjury at a prior trial, hearing, or deposition, Rule 801 D1A says it's not hearsay and can be used substantively for the truth of what it asserts.
But if it wasn't under oath at a prior proceeding, like just a statement to police or a friend?
Then generally it's only admissible for impeachment purposes to show the witness is inconsistent and maybe shouldn't be believed. It doesn't come in as substantive evidence of the facts stated. Her notes use the example of telling police you saw the defendant, then denying it at trial. The statement to police impeaches, but doesn't prove you saw them.
Okay, sworn versus unsworn is key for PIS. What about bias?
Always relevant for impeachment, her notes stress. You can always show a witness might be biased because of a relationship, financial stake, prejudice, whatever. You usually need to ask the witness about the biasing facts on cross first. Lay the foundation before you can bring in extrinsic evidence to prove the bias.
And bias goes to the weight the jury gives the testimony, not whether it's admissible in the first place.
Correct. It's always fair game to explore bias.
All right, what about prior criminal convictions? Rule 609. This one seems complicated.
It is, but her notes break it down systematically. First category. Crimes involving dishonesty or false statement. Think perjury, fraud, embezzlement.
What's the rule for those?
For any witness, defendant or not, convictions for crimes involving dishonesty or false statement, felony or misdemeanor, generally must be admitted for impeachment, subject only to the 10-year time limit. The judge has very little discretion to exclude under Rule 403.
Okay, dishonesty crimes are almost always in. What about felonies that don't involve dishonesty, like, say, assault or drug possession?
Here, the rule depends on who the witness is. If the witness is not the criminal defendant, the felony conviction is admissible unless its probative value is substantially outweighed by unfair prejudice, the standard Rule 403 test.
And if the witness is the criminal defendant testifying in their own case,
then the test is stricter, more protective of the defendant. The felony conviction comes in only if the prosecution shows its probative value outweighs its prejudicial effect. No, substantially just outweighs. Her notes emphasize this different standard for defendants.
that's a critical difference. What about the time limit?
The 10-year rule. Generally, if more than 10 years have passed since the conviction or release from confinement, whichever is later, the conviction is inadmissible unless the proponent gives notice AD. The court finds its probative value substantially outweighs its prejudicial effect. Very hard to get old convictions in.
In misdemeanors not involving dishonesty.
Generally inadmissible for impeachment, according to her notes.
Can you prove these convictions with, like, court records? Extrinsic evidence?
Yes. Her notes state extrinsic evidence, like the judgment of conviction, is admissible to prove the conviction. You don't technically need to ask the witness about it first, though you usually would.
Okay, that's Rule 609. What about prior bad acts that didn't result in a conviction? Rule 608B.
Right. This allows inquiry on cross-examination into specific instances of a witness's prior conduct if that conduct is probative of their character for truthfulness or untruthfulness, like lying on an application, cheating.
So you can ask about it on cross.
Yes, you can ask. But, and this is the huge limitation, her notes stress you generally cannot prove the bad act with extrinsic evidence. If the witness denies doing it, you're usually stuck with their answer. You can't call another witness or introduce a document to prove they did the bad act.
No extrinsic evidence for prior bad acts under 608B. Her notes hypos about the food stamp application illustrate this. Well, you can ask, but can't bring in the agent or the form if denied.
Exactly. It's limited to inquiry on cross.
What other impeachment methods do her notes cover?
Showing defects in the witness's ability to perceive, recall, or relate the events. Poor eyesight, hearing problems, memory issues due to injury or intoxication at the time. This can be done through cross-exam or extrinsic evidence.
And reputation or opinion evidence about truthfulness. Rule 608.
Yes, you can attack a witness's credibility by calling another witness to testify about the first witness's reputation for untruthfulness in the community, or to give their own opinion that the first witness is untruthful.
And if attacked, can you bolster their credibility?
Yes, if a witness's character for truthfulness has been attacked, you can introduce reputation or opinion evidence suggesting they are truthful. But you generally can't bring in specific instances of their good conduct to bolster unless character is directly at issue in the case itself, which is rare.
Okay, that covers the main impeachment methods. What about witness sequestration? Rule 615, excluding witnesses from the courtroom.
Right, the rule on witnesses. At a party's request, or on the court's own motion, the judge generally must order witnesses excluded, so they cannot hear other witnesses' testimony. Her notes say the purpose is to prevent witnesses from tailoring their testimony.
Are there exceptions, people who can't be excluded?
Yes, her notes list the mandatory exceptions. 1, a party who is a natural person.
Yeah.
2, an officer or employee of a party that isn't a natural person, like a corporation, who is designated as its representative. 3, a person whose presence is shown by a party to be essential to presenting their claim or defense, often experts or the case agent investigator. Her notes give examples of the police officer or the expert needed for a complex fraud summary.
Got it. One more witness rule. Refreshing recollection. Rule 612.
This is when a witness is on the stand and having trouble remembering something. They can be shown basically anything, usually a document, but could be an object to try and jog their memory.
And if their memory is refreshed, they testify from their refreshed memory.
Exactly. They look at the writing, it sparks their memory, they put it aside, and then testify based on their now present recollection. The writing itself doesn't come into evidence by the party using it to refresh.
What rights does the other side have?
The adverse party has the right to have the writing produced, to inspect it, to cross-examine the witness about it, and even to introduce relevant portions into evidence, usually for impeachment. Her notes say this applies automatically if used while testifying, and potentially if used before testifying if the court finds it necessary in the interest of justice.
And her notes stress distinguishing this from past recollection recorded.
Absolutely critical distinction for the bar. Past recollection recorded, Rule 8035, is a hearsay exception, used when the witness still can't remember, even after looking at the writing, but they can attest the writing was accurate when made while the memory was fresh. Then, the writing itself is read into evidence. Refreshing, witness remembers and testifies. Past recollection recorded, witness doesn't remember, writing is read in. Big difference.
Okay, crystal clear. Let's move to writings and authentication. Rules 901, 902. Proving a document or object is what it claims to be.
Right. Rule 901 lays out the general requirement. The proponent must produce evidence sufficient to support a finding that the item is what they claim it is. Her notes emphasize this is a fairly low threshold, enough for a reasonable jury to find it authentic.
What are some common ways to authenticate, according to her notes?
Testimony of a witness with knowledge is the simplest. Someone saw the document being signed or recognizes the object. Her notes use the example of a police officer identifying a unique gun they recovered.
What about things that aren't unique, like a bag of drugs?
That's where chain of custody comes in, mentioned in her notes. You show an unbroken chain, tracking the item from the time it was seized or created until it gets to court, accounting for everyone who handled it, to show it wasn't tampered with or substituted. Her notes add the chain doesn't have to be absolutely perfect, just reasonably probable it's the original item.
Comparison is another method.
Yes, comparison by the expert witness or the trier of fact, the jury. comparing a disputed handwriting sample to a known, authenticated sample, for instance. Her notes give the bank fraud check signature example.
What about ancient documents? Rule 901B.
Authenticated if 1. It's at least 20 years old, 2. Its condition creates no suspicion about authenticity, and 3. It was found in a place where, if authentic, it would likely be.
But wait, her notes had a big warning here about the date.
Huge he warning. The authentication rule uses 20 years. But the hearsay exception for ancient documents, Rule 803, requires the document to have been prepared before January 1st, 1998. Examiners love this mismatch. A 25-year-old document created in, say, 1999 might be authenticated as ancient, but not qualify for the hearsay exception. You need to know both rules.
Wow, okay, that's a devious trap. What else for authentication?
Her notes mention the reply letter doctrine. A letter sent or reply to an earlier communication is presumed authentic. Authentication of photos, videos, by anyone familiar testifying it's a fair and accurate representation. Voice ID, by anyone who's heard the voice. And telephone conversations, various methods like recognition, self-ID, business calls.
And self-authentication. Rule 902, things that don't need separate proof.
Right. Her notes list several. Official documents under seal, certified copies of public records, official publications, newspapers and periodicals, trade inscriptions, commercial paper, and certified business records, if proper notice is given. These are presumed authentic on their face.
For newspapers, her notes added a nuance.
Yeah, they're self-authenticating to prove they were published, but not necessarily for the truth of what's written in the articles or who wrote them. You might need other evidence for that.
Okay, authentication covered. Now, the favorite bar exam trap, according to Angela's notes, the best evidence rule, Rules 1001, 1008.
Also called the original document rule. The core idea, her notes explain, is that if you are trying to prove the content of a writing, recording, or photograph, you generally must use the original or a reliable duplicate. Secondary evidence, like testimony about the contents, is only allowed if you have a good excuse for the original's absence.
The absolute key tip from her notes is,
ask yourself, is the party offering this evidence trying to prove what the document says? Are the specific terms or contents legally operative or the thing being proven? If yes, the best evidence rule applies. If they're just proving a fact that happens to be mentioned in a document, but the document's specific terms aren't the issue, then the rule doesn't apply.
Her example was proving a bank was insured.
Right. You can testify the bank was federally insured. You don't need the original insurance policy itself because you're proving the fact of insurance, not the specific terms written in the policy document. That distinction is everything for this rule on the bar.
Okay, so always ask, are we proving the contents? What are the valid excuses for not producing the original, allowing secondary evidence?
Her notes list them. Original is lost or destroyed, unless the proponent did it in bad faith. Original can't be obtained by judicial process. The party against whom it's offered has control of the original and failed to produce it after notice. Or the writing is collateral, not closely related to a controlling issue.
And if one of those excuses applies, any kind of secondary evidence is okay, like testimony.
Generally, yes, under the FRE. There's no hierarchy of secondary evidence. Testimony, copies, whatever is available is usually fine once you've excused the original.
Her notes also mentioned testifying about facts learned from a writing.
Right. If a witness has independent knowledge of a fact, like they were present at an event, they can testify about that fact, even if it was also recorded in a writing. They aren't trying to prove the contents of the writing itself, but the underlying fact they know. Her example was testifying about a conversation you participated in, even if it was recorded.
And summaries. Rule 1006.
Allows summaries, charts, or calculations to prove the content of voluminous writings, recordings, or photos that can't conveniently be examined in court. But, her notes add, the originals or duplicates must be made available for the other party to examine.
Okay, deep breath. We've arrived at Mount Hearsay. Rules 801, 807, the most tested topic, right?
Absolutely. Got to know hearsay inside and out. So the definition first, Rule 801, an out-of-court statement offered in court to prove the truth of the matter asserted. Break it down.
Okay. 1, statement, oral, written, assertive conduct. 2, made out of court, not during this trial or hearing. 3, offered to prove the truth of what the statement asserts. TMNA. If all 3 apply, it's hearsay. Unless
it falls into one of the exclusions in Rule 801D or an exception in Rules 803 or 804.
Let's start with the 801D exclusions, things defined as not hearsay. Her notes highlight prior statements by testifying witnesses.
Right. If the declarant testifies and is subject to cross, certain prior statements are excluded from the hearsay definition. We already hit prior inconsistent statements made under oath. Those are 801D and 1A. Not hearsay, usable substantively.
What else in 801D?
Prior consistent statements offered to rebut a charge of recent fabrication or improper influence, if made before the motive to fabricate arose, and prior statements of identification of a person made after perceiving them, like a lineup ID. Her notes photo array example fits here. If the witness testifies and is subject to cross, their prior ID comes in as non-hearsay, substantive evidence.
Okay. The other big 801D category is opposing party statements. Rule 801D, often called admissions.
Yes, these are statements made by or attributable to a party offered against that party. Crucially, her notes emphasize these are not hearsay by definition. Doesn't matter if the party believed it was true or if it was against their interest when made.
What kinds of statements qualify, according to her notes?
The party's own statement, obviously. Adoptive admissions where a party manifests belief in someone else's statement, sometimes even by silence if a reasonable person would deny it. Statements by someone authorized by the party to speak, statements by the party's agent or employee concerning a matter within the scope of employment and made during the employment relationship, and statements by a co-conspirator during and in furtherance of the conspiracy.
That agent-employee one has specific requirements her notes stressed.
Yes, must concern a matter within the scope of employment A and D be made during the existence of the relationship. Her notes examples of the fired truck driver or repair tech making statements after employment ended show why those statements wouldn't qualify against the former employer under this rule.
And her notes implicitly contrasted these party admissions with statements against interest.
Right. Quick recap. Party admission, 801D02, not hearsay, offered against a party, declarant availability irrelevant, statement need not be against interest when made, statement against interest, 804B3, requires declarants unavailable, statement must be against interest when made. Very different rules, easy to confuse on exams. Her, this may be my fault example, is a classic party admission.
Okay, those are the 801D exclusions. Now, for the actual hearsay exceptions in 803 and 804, let's start with Rule 803, where the declarant's availability doesn't matter.
Right. Key 803 exceptions highlighted in her notes. Present sense impression, 803.1. Statement describing an event made while or immediately after perceiving it. Contemporaneity is key. Her, he hit me, stop him. Example fits.
Excited utterance, 803.2. Statement relating to a startling event made while the declarant was under the stress of excitement caused by the event. Timing can be a bit looser than PSI, but stress is crucial. Her pedestrian example works here.
Statements for medical diagnosis or treatment. Made for and reasonably pertinent to medical diagnosis or treatment. Covers medical history, symptoms, sometimes even the cause if relevant to treatment. Doesn't usually cover fault, unless maybe in abuse cases where perpetrator identity is medically relevant.
Business records, 803.6. This one's huge and complex. What are the key elements from her notes?
Record of an act, event, condition, opinion, diagnosis, kept in the course of a regularly conducted activity of a business, broadly defined. Making the record was a regular practice of that activity, made at or near the time by someone with knowledge, or from information transmitted by someone with knowledge and a business duty to report. Authenticated by custodian, and circumstances don't indicate untrustworthiness.
Her notes stressed regular practice of the business.
Yes, not just the individual's personal habit. Her corporate executive's personal notes example was inadmissible for this reason. Also, the source of the information must have personal knowledge and a business duty to report it or transmit it from someone who does. And the business has to rely on these records.
What about police reports as business records?
Her notes say they might qualify in civil cases, but often contain layers of hearsay. For example, officer writing down what a bystander said, and police observations are excluded against criminal defendants under the public records exception anyway.
Speaking of which, public records 803, what does that cover?
3 types, according to her notes. Records of the office's own activities. Matters observed pursuant to legal duty, but not police observations in criminal cases. And factual findings from a legally authorized investigation, but not against a criminal defendant. Reliability is key. Her fire marshal report example fits here.
And like business records, there's an exception for the absence of a record.
Yes, absence of business record, 803.7, and absence of public record, 803.10, allow proof that something didn't happen by showing it's missing from records where it normally would have been recorded. Her medical chart and jail record examples illustrate these.
Her notes briefly mention some other 803s, property records, family records, market reports.
Yeah, records of documents affecting property interest, 803.14, statements in those documents, 803.15, family records like Bibles, 803.13, and market reports, commercial publications, 803.17, are all exceptions where availability doesn't matter. Less frequently tested maybe, but good to know they exist.
Okay, now Rule 804 exceptions. These require the declarant to be unavailable. What counts as unavailable?
Her notes list the grounds from Rule 804A: asserting a privilege, refusing to testify despite a court order, lack of memory, death, or serious illness, or absence from the jurisdiction despite reasonable efforts to procure their attendance.
Got it. So if the declarant is unavailable by one of those definitions, what are the key 804B exceptions her notes cover?
Former testimony, 804B. Testimony given in a prior trial, hearing, or deposition, now offered against a party who had, or in civil cases whose predecessor in interest had, an opportunity and similar motive to develop that testimony back then.
Dying declarations, 804B2. Statement made while believing death was imminent concerning the cause or circumstances of the impending death. Admissible in homicide prosecutions in all civil cases. Her notes explicitly state the declarant doesn't actually have to die, just believe they were dying when they spoke, must be based on first-hand knowledge.
Statements against interest, 804B3. We contrasted this with party admissions earlier. This requires unavailability, and the statement must have been so contrary to the declarant's pecuniary, proprietary, or penal interest when made that a reasonable person wouldn't have said it unless it were true. Her notes add that statements against penal interest offered in a criminal case need corroborating circumstances indicating trustworthiness.
Her notes also mention statements of personal or family history, 804B.
Right, statements about birth, marriage, divorce, ancestry, etc.
Okay, that covers main exceptions. What about hearsay within hearsay? Rule 805.
Double hearsay, or layered hearsay. Her notes are blunt. Layered hearsay must have an exception at each level. If a business record contains a statement made by an outsider, the business record itself might fit 803.6, but the outsider's statement inside it needs its own exception or exclusion, like party admission, excited utterance, etc., to be admissible. Her car license plate example, PSI within PSI, worked, but the wife testifying about husband's statement about defendant's threat didn't, as both layers needed an exception.
Makes sense. And her notes reminded us about statements not offered for their truth.
Crucial point. If an out-of-court statement is offered for some reason other than to prove the truth of what it asserts, it's simply not hearsay in the first place. No need for an exception.
Like what kind of reasons?
Effect on the listener, for example, to show why someone acted reasonably after hearing a warning. Verbal acts or words of legal significance, like words forming a contract or making a gift. Impeachment, like prior inconsistent statements not under oath. Her milk dealer's offers example showed statements admissible for their legal significance as offers, not their truth.
Got it. What about the residual exception? Rule 807.
The catch-all. Her notes mention it's for hearsay not covered by 803 or 804, but having equivalent guarantees of trustworthiness, being material, more probative than other available evidence, and serving the interests of justice. Requires notice. Her notes include an example, but also say it's rarely tested. Probably low priority for bar study.
Okay. And one last hearsay-related point. The Confrontation Clause. Sixth Amendment. Criminal cases only.
Yes. Criminal defendants have a right to confront witnesses against them. Her notes explain this means testimonial out-of-court statements, like affidavits or forensic reports prepared primarily for trial, are generally inadmissible against the defendant unless the declarant is unavailable and the defendant had a prior opportunity to cross-examine them.
What counts as testimonial?
Generally, statements made with the primary purpose of creating evidence for prosecution. Statements made primarily to help police respond to an ongoing emergency are usually considered non-testimonial and don't trigger the Confrontation Clause. Her notes list factors for determining if an emergency was ongoing.
Phew. Okay, that was a massive tour through evidence rules. Now let's try to synthesize the key bar exam tips from Angela's notes that we've touched on.
Definitely. For the MBE, number 1, FRE is king. Watch out for common law answer choices.
Number 2, procedure matters. Timely, specific objections and offers of proof are critical. Don't rely on plain error.
Number 3, from her source notes, shut up and pick it. Once you've reasoned through an MBE question and found the answer matching the rule and facts, commit to it. Don't overthink yourself into a wrong answer.
Number 4, the best evidence rule trap. Always ask, are they trying to prove the contents of the writing? If not, the rule doesn't apply.
Number 5, character evidence. Know the propensity rule prohibition, the amiamic exceptions, and the 403 balancing notice rex, and the habit distinction, frequency plus particularity.
Number 6, impeachment methods. Know the rules for PIS, sworn versus unsworn, convictions, dishonesty versus other felonies, defendant versus witness, 10-year rule, and prior bad acts. Cross-exam only. No extrinsic evidence.
Number 7, hearsay. Master the definition, the 801-day exclusions, SPS, party admissions versus statements against interest. And the key, 803, 804 exceptions. PSI, EU, medical, business, public records, former testimony, dying delegates, statements against interest. Remember, hearsay within hearsay needs exceptions at each level. And don't forget non-tanama uses.
Number 8, privilege distinctions. Attorney-client, communication, legal advice versus work product, litigation anticipation materials, spousal testimonial, crimsal, witness holds, versus marital communications. Any case, both hold during marriage. Remember Erie for state privilege and federal diversity cases.
And maybe number 9 for essays. Structure your analysis. Identify the issue, state the rule, apply the facts, discuss exceptions, balancing, conclude. Her notes model this approach.
That's a great summary of the key takeaways and tips embedded in her notes. Excellent.
All right, before we wrap up.
Just a few important things to remember about this deep dive.
Right. First, Angela's a student, just like you listeners. She's not an expert. She hasn't passed the state bar yet. These are her study notes.
Yeah, and neither Angela nor us bots, Claude and Ma, are giving legal advice here. None of this should be taken as legal advice. You know, AI isn't a substitute for actually studying the law yourself.
Totally. Also, AI isn't perfect.
Yeah.
Sometimes we might make mistakes in interpreting or explaining. Angela does try to catch any errors when she reviews the notes, but always double-check against official sources.
And please, if you're driving right now, safety first. If listening to us banter about evidence is distracting you from the road, please hit pause. Listen later when you can focus safely.
Absolutely. And a final big thank you to Angela for letting us use her fantastic evidence notes for this deep dive.
If you need to reach Angela, the email is podcast@studyforthebarinyourcar.com.
And for those freelance law clerk inquiries, it's hello@legalwriterandlawclerk.com.
Okay, tradition dictates. Drink time. Ready.
Uh-oh. Lay out on me.
Why did the defendant bring a compass to court?
I don't know. Why did the defendant bring a compass to court?
To find direction in the case. Get it? Direction.
Sighs dramatically.
Yeah.
Okay. That wasn't terrible.
This is Claude and Ma, your AI bots, signing off.
See you on the next episode. Goodbye and thank you.